Good afternoon, everyone. Thank you so much for joining us for our webinar, Contracts and COVID-19. My name is Sarah Cooney and I'm the manager for London and Surrey at the Lloyds Bank Foundation for England and Wales. We're just giving it a few more minutes while people join us. We are going to be recording the session, but the chat box won't be shown in the recording. So if you do want to introduce yourself, and there's no obligation for you to do so, please do so in the chat box. I'm joined this afternoon by my colleague Juliana MacDonald from the Lloyds Bank Foundation, Adriano Mancinelli from TrustLaw, and with whom we're co-hosting this webinar, and also our colleagues from Allen Overy, Will Rawlinson, Malika Abidi, and Victoria Williams, and welcome to our panelists also. Today's webinar is about the impact of COVID-19 on the kinds of commercial contracts which your organization may be party to, and really sort of looking at what your options are if you're unable to fulfill your contract as originally agreed, and what your next steps or next actions could be. Our co-host, as I said, for this webinar is TrustLaw, which is the Thomas Reuters Foundation Global Pro Bono Service. TrustLaw connects non-profits and social enterprises with law firms that can provide them free pro bono legal advice. They support a wide range of organizations and have a wealth of experience working with charities from all sizes, including small charities. I'm sure many of you know of Allen Overy. It's a global law firm who are committed to using their position to influence change. They work alongside world-leading businesses to support them to grow, innovate, and thrive. And we are really grateful for our colleagues from Allen Overy today for giving us their time and expertise. So welcome to everyone who's joining us today as a panelist and as a participant. And I'm now going to hand over to my colleague Juliana, who's going to explain how the webinar will be managed.
Brilliant, thank you, Sarah. So just kind of a few housekeeping rules. So your microphones are all muted, and your videos aren't on screen, so you won't be able to be seen. But I can kind of let people know we've got near enough 40 people on this webinar. So it's a really great webinar. I'm really looking forward to co-hosting this with TrustLaw. Going through, if you have any questions, there is a Q&A box at the bottom, so do feel free to use the Q&A function, and I know that there is an allocated slot for question and answers during this webinar, so we'll be going through those questions at that point, but do feel free to pop them in. The Q&A will only be seen by the panelists, so to remain anonymous and keep that going, it will just be seen by the those questions for you. As my colleague Sarah mentioned, we are recording the webinar, and we'll be sharing this afterwards along with some extra key information. So we'll be hosting this recording on our website, on the Lloyds Bank Foundation YouTube channel, and I believe that we'll be sharing some TrustLaw as well, and they'll be sharing that across their platforms. So I know that Sarah also mentioned this before, but anything that's written in the chat you won't be able to see in the recording. So as we said, it's been great that you've all introduced yourselves, and we really welcome you, and that will just be kept within this webinar and not shared. So we really do hope that you find this webinar useful and enjoyable, and we're really looking forward to co-hosting this. So please do get involved by posting questions. If there's anything you do want to pop in the chat, that's absolutely fine. But for now, I'm going to pass over to TrustLaw and Allen Overy.
Thanks a lot, Juliana. And so my name is Adriano Mancinelli. I'm the program manager for TrustLaw in the UK and Europe. I will be talking a bit more about TrustLaw and how we can support through pro bono legal advice at the end of the presentation. So I'll be very quick now. Let's just be allow me to echo the thanks to our colleagues from Allen Overy for taking the time and obviously being able to share their expertise during the webinar today. Very quickly on the agenda, you'll have the presentation from Victoria, Malika, and Will from Allen Overy, followed by a Q&A session. And then we'll be sharing a bit of information about how TrustLaw can support, specifically during the COVID-19 pandemic, and a bit of information about Lloyds Bank Foundation and their support to organizations. And then at the end, we'll be asking all of you for feedback. So I do hope that you'll find the session useful and informative. So thanks again all for joining, and thank you very much, Victoria, Malik, and Will, for your presentation. So without further ado, I'll leave it to you for the legal presentation.
Great. Thank you very much, Adriano, and thank you everyone for joining today. As mentioned, my name is Will Rawlinson, and I'm an associate in the restructuring and insolvency team at Allen Overy. And I'll be talking through a few points today on contracts. And before I start, it's worth mentioning that when I refer to contracts, I'm talking about commercial contracts applicable to businesses. So that would include charities and other not-for-profit organizations, rather than consumer contracts. And the reason I make that distinction is because there may be certain protections available to consumers under consumer contracts, which are not available to businesses under commercial contracts. So just to establish the scope of the type of contracts we're talking about today. So just beginning with some very basic principles and ground rules, which is good to bear in mind when you come to read and interpret your contracts. Of course, the circumstances of COVID-19 are having a significant effect on parties' abilities to perform under their contracts for a variety of reasons. So it's really important that at the outset, you fully understand what your rights and obligations are under your contract in that context. So Adriano, would you mind just moving on to the next slide, please? Sorry. Okay. So a good starting point to think about when you come to review your commercial contracts is that under English law, the default position is that a contract must be performed and it will be judicially enforced according to its terms. So courts will look to enforce your contracts unless there is a really compelling reason for them not to do so. And that's important to bear in mind. So notwithstanding all the circumstances of COVID-19, when you enter into a contract, the parties are assumed to accept a certain degree of risk. There is always a risk that one party may not perform their obligations under the contract. And so in a situation of dispute between parties, and let's imagine for these purposes that the dispute went to court, a court is fundamentally going to have to regard to some basic guiding principles when considering how to resolve the dispute. So firstly, as you might expect, the court's going to look at the express terms of the contract. What does it actually say? It sounds very obvious, but ultimately many disputes are going to come down to a very close reading of what the contract says. They will also look at the context in which the contract was written, and they will also apply an objective test to consider what was the objective intention of the parties when they entered into the contract. And by that I mean, what would a reasonable person reading the contract understand the parties to have meant when they entered into it? So I mentioned that the court will consider express terms. It's also possible the court might imply some terms into the contract. So a contract is normally understood by reference to its express terms, but a party might say, yes, this is what the contract says, but in practice, we both intended the contract to operate in a certain way. So it's possible a court might agree with that approach and imply a term into a contract. And we'll come on later to terms which must be expressed, such as force majeure clauses, and terms which cannot be implied into contracts. So finally, in the situation of dispute, you may find that there has been a breach under one of your contracts. So perhaps a counterparty has not performed all their obligations. Now, typically, the fundamental guiding principle is that where there's been a breach under a contract, the innocent party will have a right to damages to recover any loss that they suffer as a result of the other party's breach. So today, we're going to cover a series of points where such a breach might be excused. So if one party cannot perform under the contract, what might be the options available to them? So as the slide says here, in that situation, the onus is on the party who cannot or does not want to perform under the contract to prove why they are not obliged to do so. So in order to do this, they're going to have to avail themselves of some contractual or common law defences in order to prove why their breach was justified. So today, running through them then, we're going to talk about contractual termination. So that's where there is an express termination right included in your contract. So can a party terminate as a result of specified events or circumstances? We'll talk about force majeure clauses. So you may hear this term a lot in the context of COVID-19. And there you're thinking about, has an extraordinary event or circumstance beyond the control of the parties occurred, which prevents them from fulfilling their obligations. We'll touch very briefly on material adverse change, which effectively would be, again, an express clause, which specifies certain events which cause a material adverse change in the nature and circumstances of the contract and potentially give a party the right to walk away. And yes, worth mentioning also change in applicable law. So perhaps new legislation has been brought in which materially affects the party's ability to perform under their contracts. That's something which perhaps is more related to the doctrine of frustration, which my colleague Vicky will talk about. And yes, so my colleague Vicky will talk about the common law defences here as well. So common law termination. So that's where we don't have an express termination provision in the contract, and the doctrine of frustration. Adriana, could we move on to the next slide, please? Thank you. So beginning with termination clauses under your contract. So again, very important to note, these are express provisions containing specified circumstances where a party might be able to terminate the contract. And they broadly fall into two categories, and those are termination for fault and no fault termination clauses. So beginning with a no fault termination clause is where your contract might say that one party can terminate the contract without having to give any reason for doing so. Okay, so no event needs to have occurred in order for them to do that. Typically, if there is a no fault termination provision, you would expect there to be a very long notice period that party has to give. So they'd have to say, okay, we'll give you 1 month's notice that in 1 month from now, we want to terminate our obligations. So it's good to look out to see whether your contract contains that. The second type of contractual termination clause are the for fault provisions. So these would be carefully thought out instances where you may decide, okay, this situation has occurred, so one party has a right to terminate the contract. So an example of this might be if the counterparty goes into insolvency. My colleague Malika will be talking about exactly what that might mean, what the term insolvency actually means in practice. But in that circumstance, the parties may agree at the outset that that gives rise to a right to terminate. When trying to rely on a termination provision, if you're thinking about terminating a contract, it's very important, I know it sounds obvious, to really look at the clause and see exactly what the requirements are for you to be able to apply the clause. So consider, are there any remedy periods in the termination clause itself? And what that means is that a breach of the contract may occur, perhaps a party doesn't pay on a due date, but does the clause specify that they have 3 days from that payment date to remedy the breach? Because it's important to note you'll have to wait for that remedy period to expire before you actually have the right to terminate under the contract. So look out for those. Are there any minimum notice periods? So yes, there may be a requirement to give the counterparty, for instance, 5 days notice before terminating. And there may also be other formalities which need to be complied with or charges to be paid in order to terminate. And the type of formalities I'm thinking of there are perhaps notice needs to be served to certain email addresses specified in the contract, or perhaps it needs to be given by first-class post. Another point to think about when you're thinking about exercising your termination rights, this isn't on the slide, but when actually drafting or taking advice on how to frame the termination, just be careful that you reserve your rights under the contract. And what I mean by that is that when termination notices are issued, they will typically contain some sort of wording which preserves some of your rights to perhaps claim for any accrued costs you might be owed. And it will often specify that certain clauses of the contract survive the termination. And that the type of clause I'm thinking about there is a dispute resolution clause, where perhaps you may wish to litigate the claim later on. So you will want some provisions to survive. So that's the kind of thing it may be worth taking a little bit of legal advice on, just to check that you're A, terminating correctly, and B, also complying with the correct requirements and preserving your rights. So non-termination options here, it's perhaps needless to say that terminating a contract is going to have some serious effects, potentially damaging your relationship with the counterparty, or perhaps it might be damaging in the sense that your business doesn't gain the benefit of the contract. So it's going to have some impacts that will have to be considered on a case-by-case basis. So have a look at some of the other provisions in the contract which might help you work through the situation. So amendments and waiver provisions. Is it possible to waive a breach on a one-off basis? And when I say waive, that means forego a breach in one instance and allow the counterparty to remedy the problem in some other way. Or you can amend the contract, vary the contract terms. Maybe it's possible for the contract to be performed in some other way, or for some other arrangement to be reached. And that links into the practical measures there at the end. So you can consider deferring the payment dates or rescheduling the dates of performance for the counterparty in order to try and find some kind of workaround. And this is very much the spirit of the government guidance at the moment to parties considering exercising their termination clauses. They are really encouraging parties to think about alternative options. Limitation and exclusion clauses there. When I talked about understanding your rights and obligations, this is an important one to look at. So check to see whether the liability of a party is actually limited. It might, for instance, be capped at a certain amount, and some liabilities may be excluded altogether, from the termination provisions. Can we move to the next slide, please, Adriano? So force majeure clauses then. This is another express clause in a contract. It may not be called force majeure clause, but it will contain, normally they're quite consistent and they contain the same sort of wording and normally the same three elements. So just to explain what a force majeure clause is, I'll read the definition and then we'll break it down because it's a bit of a mouthful. So an express provision in a contract in which parties try to address unforeseeable future events which are beyond their reasonable control and which cause a failure or delay in a party's performance of its contractual obligations. So we've talked about an express provision, and typically what you'll see is a list of non-exhaustive possible events. And this will typically include things like acts of God, which have historically been things like earthquakes and typhoons, civil disturbance, and very occasionally you will see actually epidemic and pandemic listed in the list of events. And it is likely that COVID-19 would fall into either of those, epidemic or pandemic. However, it's not enough that COVID-19 has occurred. It wouldn't be possible for a counterparty to say, look, COVID-19 has occurred, therefore I can exercise my rights under the force majeure clause. Very simple. They will need to show that there is a causal link between the occurrence of COVID-19, which causes a failure for them to perform or delays their performance under the contract. So the key question is, you need to be thinking, how has COVID-19, how have the consequences of it caused a failure to perform under the contract? Maybe it's that as a result of COVID-19, the government have imposed restrictions on the supply of goods internationally. And as a result, a car maker has not been able to, to produce the cars it needs because it's missing essential parts. So it's important to try and establish that causal link. So the effect of a force majeure clause will also typically be expressly written in the contract itself. So it might not be the case that just because a force majeure event has occurred, the contract automatically terminates. More likely, it will have the effect of suspending a party's obligations, or it could perhaps remove liability from a party, i.e., it might say a party shall have no liability if one of these unforeseeable events occurs, which causes a failure to perform. So Again, it may not be labeled force majeure clause, but it's important to check very carefully your contracts to see whether wording like this is included, because it's designed to protect an innocent party where something's happened completely outside of their control and through no fault of their own has caused them to not be able to fulfill their contractual obligations. So just some things to think about, again, once you've established that there is a force majeure clause, make sure that the governing law of the contract is what you expect. We're talking obviously today about English law contracts. It's possible that laws of other jurisdictions might interpret force majeure clauses differently. So a whole new set of laws may apply. Is the event in question covered? So it might be expressly listed that there's an epidemic or pandemic force majeure event. More likely than not, you'll see a sweeper clause in there, which is a kind of catch-all clause, which might say, and any other event beyond their reasonable control. So if a party is trying to rely on this kind of wording, there is some debate about whether something like COVID-19 could be captured. And frankly, it may be advisable to seek some legal advice in order to, and a legal advisor might advise on the context and the wording itself of the clause in order to give you the best possible understanding of whether a party can rely on it. Other procedural requirements, this is very similar to the contractual termination clause points which I mentioned. It is absolutely crucial that notice periods and other specified formalities are complied with, because these are effectively conditions of the force majeure clause. And if those conditions are not complied with, it's possible that any termination notice given in relation to the force majeure clause might be invalidated. So it's important to bear these in mind. Material adverse change clauses, I won't spend too much time on because I've covered, I think, the key points already. But this might be another express clause in your contract which lists some very clear and specified events which might give a party the right to walk away in a certain given situation. So typically you would see these in the context of a sale agreement, and perhaps the documents have been signed, but the buyer will want the right to walk away from the acquisition if the seller's business, for instance, collapses as a result of something, perhaps something like a change of control of the ownership of the business, or some other material breach of the contract. The buyer will want the right to walk away in that circumstance. So it will normally say materially and adversely changed some element of the contract. So with that, I'm going to hand over to my colleague Vicky, who's going to talk about frustration and common law termination.
Hi there, thank you. So as Will mentioned in his talk, there are certain defences available to contracting parties under common law, which may help a party where it is unable to comply with its obligations under a contract. And where a contract does not provide for the operation of force majeure, the doctrine of frustration may come into play. So just in terms of what frustration is, it's broadly defined as something that applies as a result of an unforeseen event outside the control of the parties, which here would be an event arising from the coronavirus pandemic. Performance of the contract has become legally or physically impossible or radically different through no fault of the parties. If a frustrating event occurs, the contract will be automatically terminated, so the parties won't need to perform the contract any longer. So just in terms of when could a contract be frustrated, as a starting point, it's worth noting that it's only in very exceptional circumstances that frustration is likely to apply. And the event relied upon, i.e. an event arising from the coronavirus pandemic, must be unforeseen. So if you've got a force majeure clause, which already provides for what happens in the event of a pandemic, it's very unlikely that you'd be able to rely on frustration as a way to get out of the contract. The classic example of a frustrating event is one where you say you have a contract to use a particular building for a concert, and then the building burns down prior to that concert taking place, leaving it physically impossible to perform the contract because the building no longer exists. That was your sort of paradigm case of frustration. But in the context of COVID-19, a frustrating event might be, first of all, illegality. So if performance of the contract is prevented because the government has made it illegal due to coronavirus. Another example could be cancellation of an event. That could result in frustration. So where you've got a contract that relates to a particular service for an event, and that event then gets cancelled, you're no longer able to perform the contract. And another example, a slightly more vivid example in the case of coronavirus is if, say, you had illness or death of where you've got a contract for personal services, so in relation to employee contracts, for example, that could be a frustrating event. Just one point to note is that a frustrating event is not one where it simply becomes more difficult or more expensive to perform your obligations under a contract. It has to be, as I sort of said, physically impossible, which is why it's such a high threshold. One thing that we've sort of been asked about previously is what about leases? That's quite a common question at the moment in the context of COVID-19. Whether they could be frustrated because, say, a business is unable to open their premises during the lockdown period. Now, the sort of general, it's obviously going to depend on the terms of the lease, but generally where you've got, say, a short period where you're unable to open a business of, say, a few months during lockdown, that's not likely to frustrate a lease which has a term of, say, 10, 20, 30 years in which you can use the premises. So it's quite unlikely that could fall into a frustrating event. So that's everything I was going to say on the common law defence of frustration. If we can move to the next slide, please, Adriana, that's great. I was going to discuss termination at common law. So Will has already mentioned that there might be circumstances in your contract where you can terminate under sort of the general contractual provisions. But if there aren't those circumstances, there are also possibility of terminating at common law for a repudiatory breach of contract. Now, a repudiatory breach of contract is a breach that is so serious that it gives rise to a right of the innocent party to terminate the contract. And once such a breach has occurred, that innocent party, i.e. the party that's not in breach, has the option to either accept the breach and terminate the contract, or they can affirm and push the other party to perform, so forego their rights to terminate the contract. As I mentioned, it's only repudiatory breaches give rise to this right to terminate, and those are particularly serious ones. And the types of breaches that they could include are a breach of a condition. So you might see in your contract a particular section which covers conditions of the contract. It could be a serious breach of a term that goes to the root of the contract. So something that's the whole purpose of the contract, where that's been breached, that could give rise to a right to terminate. Or indeed a refusal to perform. If your counterparty turned around and said, no, we're not going to comply with our obligations under the contract anymore, that could give rise to a right to terminate. Whether or not a breach is repudiatory is very fact specific, and so similar to what Will has mentioned before, it's best to seek advice on whether you have a right to terminate. But just by way of example, a delay in making a payment under a contract is unlikely to be a repudiatory breach, particularly if you had a provision in your contract providing for interest on late payment, because in that situation, the parties have already sort of thought about the consequences of what would happen if there was a late payment. On the other hand, a failure to do the very thing that's the purpose of the contract is likely to amount to a repudiatory breach. So, for example, if you had a contract for a particular speaker to attend an event and then the speaker pulls out, that could be a repudiatory breach of contract. In some cases, repeated breaches may also amount to a repudiatory breach, but as I said, it's very fact specific, so there's no sort of general sort of rule when it comes to this. It's very much interpreting the contract and the sort of context of the breaches. Just to cover a few wider considerations to bear in mind if you're thinking about terminating for a repudiatory breach. The first one is have a think about your relationship with your counterparty. This is a point that Will touched on. If you've got an ongoing relationship with that counterparty, termination may not be the way forward. The second thing to bear in mind is that whilst you don't need to make a decision immediately whether or not to accept the breach and terminate the contract or affirm, you can't wait forever, and the longer you leave it, the more likely it could be that you have been found to have actually chosen the option of affirming the contract. So if you sort of carry on performing your obligations under the contract and so does your counterparty, it might be said that you've lost that right to terminate. A third point to consider is whether you might be better off opting for a contractual termination instead of common law termination. So common law termination for repudiatory breach can be quite risky. It's not very easy to always tell whether or not you have that right to terminate. As I said, it has to be a particular type of breach that gives this right to terminate. And so the danger is if you've identified something which doesn't turn out to be a repudiatory breach and you attempt to terminate, you yourself could be in breach of contract. So quite often parties decide to rely on contractual termination instead, because that's just a bit more straightforward. And then the final point to cover on this slide is damages. So if you terminate for repudiatory breach, you're also able to claim damages for losses that arise resulting from the breach, as well as what's called loss of bargain damages, which is essentially an amount to compensate for the lost opportunity to receive future performance of the contract. So you could potentially claim more damages through terminating for a repudiatory breach than you might otherwise be able to if you were terminating pursuant to contractual provision. If we could move to the next slide, please, Adriano. That's great. So just finally, I'm just going to cover a few practical steps to bear in mind. The first is, as I've already mentioned, this is quite a complex area, and commercial contracts can be notoriously difficult to interpret. So it's always best to seek professional advice in these circumstances. When it comes to negotiating with counterparties, it's important to ensure that you understand your position. So perhaps take some advice before reaching out to your counterparty. And it's important also to engage in some prompt dialogue with counterparties. So don't sit on any issue for too long. Identify what the point is and reach out to them as soon as possible. Some of the points that we have covered, such as frustration and termination for a repudiatory breach, are things that are quite difficult. As I've mentioned, they're quite sort of high hurdles to meet to rely on those things. And so actually you might not necessarily want to terminate for frustration or repudiatory breach, but you might want to just mention these things as potential negotiating points with your counterparty instead. Again, consider each relationship on a case-by-case basis. if you've got an important ongoing relationship, you may not want to raise these points with them, and you might want to take a different approach. And so whilst theoretically you could allege that there's been a breach or that you have a right to terminate, you might not want to do that. And if you're experiencing financial difficulties caused by COVID-19, it might be that's something that you can use as an opportunity to renegotiate your terms. If your counterparty is aware that you're facing potential insolvency, for example, they may be more amenable to coming to the negotiating table and renegotiating some of your terms of your contract. And then just finally, it's always good to keep a register of contracts. Make sure you have an accurate copy of all of your contracts. It could be useful during these times to review your contracts for any useful provisions, the types that Will has spoken about. So does it have a force majeure clause? And just one final point, in terms of your company's insurance policies, if you have any, it's always worth considering whether you might be required to notify an insurer of a potential claim if you're having, potentially getting sort of letters before action or anything like that from a counterparty. That might be circumstances in which you might need to notify an insurer. So that's everything I was going to say, and I was going to hand over to Malika, who's going to talk about some insolvency considerations.
Thanks, Vicky. Thanks, Will. We thought it would be helpful just to take a step back and just discuss the context in which you might be considering your contracts. Obviously, it's a very difficult time, and you might find yourself in financial distress of different kinds and different levels. This slide sets out what the legal definition of insolvency is, and I will explain it, but just to let you know, there are two tests that are typically used by courts to consider insolvency. One is a balance sheet test. It's just to see whether the total of your liabilities exceed your assets. Is there an imbalance between what you think you owe and what you think you have? And a similar theme runs through the second test, which is the cash flow test, and it is basically matching what's coming in against what has to go out. And why I would say this is important to consider is because you all know trustees, directors, they owe duties to the company, they owe duties to people, that they have maybe entered into contracts with or borrowed monies from. And the duties sort of switch when you enter into a situation of financial distress. And what I mean by switch is, I'll give you a very simple example. You might have, had a small bank loan where you owe and you're paying back about £500 a month. You can easily meet that payment, usual course of business. There's no problem. You might be considering what else you could be doing. You could be maybe getting new employees in or renting a new office space. But let's say COVID happens, suddenly your plans for the year have come under stress. You're not really sure if all of your income that you were counting on is coming in. You sit down and you really look at this, and there is now maybe a point in time in the next 3 to 6 months, you may not be able to pay the £500 per month. And what the law tries to say is that in that situation, you have to really think hard whether it makes sense to be getting new employees or whatever your original plans were, and to really relook at how you are using your cash resources in those situations. And we wanted to actually, if we could go to the next slide, talk through these things in a sort of practical way. Thank you, Adriano. There is a list of questions or things that you could think about, which probably tie in a lot with some of the things that you anyway do. But I would say that there are two key themes if I could sort of emphasize on. One is to make, of course, a contingency plan. It's always good to have a plan, to map out both the income and expenses over the next 3 to 6 months, or maybe 12. I'm not really sure how long this pandemic is going to last and affect us all. It's also really good to think about things like, as we've discussed, should you be having more conversations with your, people you're contracting with, people that you've, employed, or other scenarios that might be relevant. And the second thing that I would say, and I think all lawyers tend to emphasize this a lot, which is really document your decision making. And I know that when a lawyer says document, it's a different lens of paper that we're talking about when, someone who's not from a legal background tends to write about it. But I would emphasize again that putting down all your reasons for anything, including things like, not sure we can perform under this contract, not sure our counterparty can perform under this contract, maybe we should be taking some steps here, having a proper document that lists those reasons down is actually quite helpful. We're going to wrap up the session, but as Vicky and Will have said, all of these areas are quite complex, so do obtain independent legal advice if you think that you really need to discuss any of these issues in more detail. And that's all from the Allen Overy team. I think we are open for questions now. Yeah.
Thanks a lot. Yeah, I thought it was brilliant, and obviously now we are opening. I think we've got some 10 minutes for the Q&A session. We have actually already received a question while you were during the presentation. So the question says, the organization would need to hold a gala fundraiser on the 26th of March, and they asked the hotel to receive a total refund and terminate the contract. The contract had a force majeure clause. The hotel preferred to postpone and move the date, and they continue to say that they will only provide refund once we had confirmed the date, and now they say that force majeure doesn't apply. However, the organization obviously cannot hold a gala with 400 guests due to government restrictions. Any thoughts? Any advice?
Yeah, I can try and pick this up. So I think the first thing to say is that this is going to depend on a number of factors. The first thing to think about immediately is, when was the contract entered into? Was it entered into before COVID happened, before it became, I suppose, reasonably foreseeable to think about this kind of event and whether it could actually go ahead, or was it quite a recent contract? So that's just the first thing to say. In terms of the force majeure clause itself, again, it's going to be unfortunately quite dependent on what the actual wording of the clause says. So firstly, you think about, is this epidemic and pandemic situation expressly covered? So that's the first thing to think about. That might give a party a better chance of relying on the clause. Is there another sweeper provision which says, any other event beyond the reasonable control? So that's going to be another point to think about. And also, the force majeure clause will probably specify the effect of what happens if it's relied upon. So it might not say that you can terminate the contract. It might indeed say that that the hotel's performance of its obligations need to be postponed for a period of time. So that might be, in this current circumstance, postponing the gala conference until such time as when the government does permit large gatherings, or perhaps gatherings with social distancing requirements. So one important thing to say, which I don't know whether we've highlighted on the talk in relation to breach, is that it's not sufficient just to accept that the counterparty has breached your contract and for you to go, okay, and now I can terminate and I can get a refund. There may be, under common law, there is a duty to mitigate the loss. So you will need to think about, okay, we can't hold the gala under the current circumstances, but for instance, if the government does allow such events to be held with very strict social distancing measures, can we look at that kind of option in a couple of months' time? Is there any scope for doing things virtually, or having less people attend the gala conference, and perhaps some kind of discount being applied, or some other arrangement being brought about? So I think my overall response to this would just be very cautious about deciding whether the force majeure clause applies. If it's not expressly covered, the event in question, it may be worth taking some legal advice and ultimately try to think about other ways in which both parties can be at least vaguely happy with the situation before going down the termination and refund route, if it's not immediately clear that you can apply the force majeure clause.
Just one thing that I would add to that is because you have got a force majeure clause, it's quite unlikely that you would be able to rely on frustration as an alternative way of getting out of your contract. So that wouldn't be open to you. Depends on the wording of the force majeure clause, but it's unlikely to be open to you.
Thank you. And can I just remind people that there is a Q&A and chat function, so you can choose either to put the request. If you use the chat, other participants might be able to see that. We got another question that might be similar in a situation, but actually they say that that contract didn't have a force majeure clause. So the question reads, we have a situation where a patient's conference venue at an hotel was contracted pre-COVID-19, and they paid a 10% deposit on signing. There was no force majeure clause. The hotel management closed the building 2 weeks before the conference, so the conference could not be held. Are we entitled to the return of for the deposit? The hotel is saying that they're not going to deposit to refund the deposit, even though they decided to close.
I think it sounds. I mean, obviously, it depends on the wording of the contract and the circumstances in which you're able to get your deposit back. So you need to have a look through the contract and take a look at that. But it sounds to me like the type of thing that where you potentially could get your deposit back. Particularly as the contract was entered into prior to COVID-19. So, you know, presumably none of the parties had this in mind. And it could well be there could well be a frustrating event. I mean, it's quite difficult to tell based on the facts here, but it's definitely something to explore with a legal advisor.
And I think it's worth adding that a lot of people at the moment are just saying no. I mean, that's their standard response for all sorts of deposit requests. So obviously, if you are entitled to one, I think you just have to keep trying to engage with them, because I think sometimes at the moment, because of the number of claims being brought, a lot of people are saying no without really engaging on the merits of your particular case.
Yeah, that's a good
Thank
point.
you. Thanks. Just while other people ask questions, there was one that was sent in advance of the webinar that I thought was interesting, and you covered a little bit, you covered on touched on that, Malik, already. But the person was asking if there are any formal steps for trustees or directors to decide when to start looking at insolvency for an organization, and if that can be, if you could perhaps talk a little bit about that.
Yeah, sure. I mean, the law doesn't actually prescribe a particular threshold at which you have to file. So it doesn't say that, you know, you must have this kind of deficiency or you must have something XYZ to file. What it does do is it puts the responsibility very much on the directors and the trustees to make a decision. So and the tests are very much, you know, driven financially. So if you are, you know, if you are in a situation where you genuinely believe that you cannot meet your liabilities in the long term, and I don't mean, you know, in a year, maybe 3-6 months, you know, that I would say is a pretty good time to really consider. It's hard to say to consider filing for insolvency, but I would say to really consider whether there's any way to come back. So you know, you think of your alternate plans, you think whether there can be any ways to sort of, you know, really up your cash, manage your expenses and things like that. But ultimately, the call to file has to come from the trustees or the directors. And it is a factual assessment.
Great, thank you. There's one more question. I don't know whether we might have time for this and then perhaps another question. So the question is, what is classed as a reasonable amount of time to terminate a contract in unprecedented times like the present? So if, for instance, a 3-month notice period is stated in a contract, can we use frustration or any other means to give a shorter notice, for instance, 4 weeks due to financial distress?
Yeah, so this is sort of a point that goes to what Will and I were talking about. So I think generally you need to stick to the notice periods given in your contract. But as this question says, frustration may be a way of avoiding giving notice. So if there is a frustrating event, you can terminate immediately. However, it's going to be very rare that there is a frustrating event, and it's quite difficult to show this. And so I think probably you're better off following what's in your contract rather than sort of saying there's frustration and therefore I can terminate immediately. Will, I don't know if you had anything else to add to that.
No, thanks, Vicky. Just other than to say that, as I say, courts are very keen to apply the express contract terms which parties have agreed. And in the absence of a force majeure clause, as Vicky says, it's probably going to be very unlikely that frustration will be brought about, and actually have some effect. I think I'm right in saying that I don't think, for example, that the SARS epidemic a few years ago gave rise to many, if any, cases of frustration being applied as a matter of course, across commercial contracts, or at least I haven't heard of any. And so I think, yes, as Vicky says, the best starting point is to look at the contract terms and try and apply them as best you can.
Thanks, that's great. I think so. There's a very last question that says, given the current uncertainties, would you recommend including epidemic or pandemic clauses in future contracts, and where is best to do this?
Yes, I think that would be reasonable. I think the more, as best as you can expressly cover potential future events, that is going to give you more cover ultimately if you ever seek to rely on a force majeure clause. And in terms of where it should be, I think that should be included in a standalone force majeure clause. And if you need some advice on wording of that, again, it may be good to take some legal advice.
It might just be worth adding that if you enter into a contract in the next 10 or 12 months where COVID is still very relevant, it would be hard for you to say that you're then relying on COVID to terminate the contract. This would be a future pandemic or an epidemic. If you are already in the midst of a pandemic and choose to enter into a contract, it would be you cannot then say we're in the pandemic and then we're going to terminate it. So just to add that.
I think that's a very good point. Thank you, Malika. And I would thank Malika, Victoria, and Will once again for the brilliant presentation and answering questions. Just a few words about TrustLaw. We are a global pro bono legal network run by the Francis Reuters Foundation. We've been working to increase our response during COVID-19. So just to mention a few of the resources that you can get through TrustLaw. We've created a website where we've listed all the legal resources that our legal members, law firms such as Allen Overy, have put together to help organizations navigate these times. On that same website, you will also find the recordings of all the webinars that we've run to date. This was part of a series of webinars to respond to the COVID-19 crisis, together with a COVID-19 legal checklist that we put together. So the way the checklist works is quite simple. It's a list of questions. Today we've discussed about the legal implications of COVID-19 on contracts and contractual rights and obligations, but obviously the pandemic is impacting a lot of your operations, and it has very different legal implications as well. They go from employment contracts and employment relations to perhaps making sure that your governing documents are still up to date with your activities. So I do urge to have a look at the checklist, and that will help you identify some other challenges that you might have or things that you might want to talk about with law firms. It is free to join TrustLaw whenever you can. It's an online application. Some of you will already be TrustLaw members. You know that you can come to us with a request and on the TrustLaw portal. Everyone else, you can submit an application. We'll make sure to get back to you as soon as possible. And in particular, for any COVID-19 related matters, we're now handling them on a urgent basis. So trying to minimize as much as possible the time that that passes between you come to us with a request and when we can connect you with a law firm that can provide pro bono advice. So please do get us in touch. All the links will be available to you after the webinar. We'll send follow-up emails and the slides as well. So just thanking again the lawyers at Allen Overy. Back to you, Sarah.
Forgive me, just took me a moment to unmute there. So I just wanted to take the opportunity of introducing the Lloyds Bank Foundation for England and Wales to you. I know many of you are our grantees, but there's also quite a number of people on this call who may not be familiar with the foundation. We are an independent charitable trust funded by the Lloyds Banking Group, where we've been in existence now 35 years, and our work is to partner with small and local charities helping people to overcome what we call complex social issues. We do this in three ways. We fund charities through our grant programs. Alongside our funding, we offer a wide range of development support, and we also work with our charities to help feed in and influence positive change and policy in terms of both policy and practice. If we go on to the next slide, please. So in terms of development, many of you have already accessed support through our enhanced program. So for those charities that we're funding, alongside our funding, we also offer access to a range of support that can include consultancy support from both independent consultants and statutory and national sector bodies. It can be training, there's mentoring, and also a wide range of resources. And additionally, we've also developed quite a number of additional support offers, especially designed to help our charity partners through this period. So if you are one of our grantees, please do, and you're not already accessing that support, or you haven't checked out what we can offer you recently, please do visit our website and or speak to your grant manager. So we also have an ask for you. In terms of our campaigning and influencing work, we're currently involved working with NCVO and other sector bodies, including Locality, Children England and Clinks, to gather together evidence around commissioning. And what we're looking to do is to continue the work that we've been involved in, looking to push for improved and better practice by public sector bodies when commissioning services and managing practices. So to do this, we really need examples both of good and maybe not so good commissioning practice. And right now we're particularly interested also in examples of where you've had those relationships and how they've been managed since March. We're asking organizations and charities to submit their experiences and their stories through the NCVO website. The address is there, www.ncvo.org.uk/public service contracts. And we hope that together as a voice we can help to influence positive change, and also that the information coming out of there will be useful to you in the longer term.